whoever's coming is in, like a seat for Isaiah, or who is it? I don't know. Is that right? Am I right?
Yeah,
All right.
somebody needs a seat open.
Yeah.
All right, thank you so much for joining us. We're very excited to be hosting this panel of distinguished guests. A couple of maintenance announcements. One is we had a couple complaints about the Wi-Fi password. You haven't put it under the group. It's not its grouping is not a password code. It's like the group code. I think that's vague enough that you can figure out what's going on. We also wanted to give a special thanks to the Penn Law Students for Reproductive Justice for assisting us in putting this together. We really do hope that this event today will be the starting point of further collaborations between the Federal Society and other student groups on campus. And in the spirit of true dialogue and discourse, we've tried to assemble, to the best of our ability, a bipartisan discussion and multidisciplinary discussion, I should say, on this Hobby Lobby case and the HHS mandate, which requires businesses to pay for contraceptive insurance. We have a very unique, interesting intersection between public policy and religious conscience issues. And the multidisciplinary aspect is one from a more broad philosophical perspective. And for that, we've brought in Professor Patrick Deneen, who is an associate professor of political science at the University of Notre Dame. He previously held faculty positions at Princeton and Georgetown. He is also the author of Democratic Faith and the Odyssey of Political Theory. We've also brought Alexander Guerrero from the Penn Bioethics Department. He is a lawyer and political philosopher, currently appointed as assistant professor of philosophy and of medical ethics and health policy. That's quite a title. At the University of Pennsylvania. His scholarship focuses on the legitimacy of democratic decision-making and its relationship to the limits of human reason. He earned his JD and PhD at NYU. And then, so that's our sort of philosophical side of things, and we'll have Professor Deneen start and Professor Guerrero follow. We then move to sort of the legal aspects of the argument. And there we have a very distinguished two guests. From the Alliance Defending Freedom, we have Jordan Lawrence. He's a senior counsel and an executive vice president at ADF. And he is one of the most active Christian, which is one of the most active Christian public interest firms. He is head counsel in the Elaine photography case. And, you know, essentially, if there's anything that involves Christian religious freedom causes, you can find Jordan Lawrence's name somewhere involved in briefs or prepping the lawyers. It's a very distinguished person we have here. And then we also have Bridget Amiri, which we're delighted to have from the ACLU. She is a senior staff attorney at the Reproductive Freedom Project, where she has worked since 2005. The current docket includes a challenge to Texas's restrictive abortion law and South Dakota's law requiring women seeking abortion to first look to a crisis pregnancy center. Ms. Amiri was previously an attorney at South Brooklyn Legal Services in the Foreclosure Prevention Project and at the Center for Reproductive Rights. And with that, I'm going to get out of your way. And we've allowed each speaker about 12 minutes to present their point of view, and then we will follow that up with community Q&A. So we look forward to audience participation with this. So without further ado, Professor Deneen.
Thank you very much. Thank you, especially to Rob Day, who was my point of contact and invitation to be here. I'm going to request a higher honorarium, though, because to be able to speak for only 12 minutes is much harder than if you had given me an hour. So I will try to compact profound and deep thoughts in that amount of time. I'm neither a lawyer nor, much worse, a law professor. So you can expect to learn from me very little about the Hobby Lobby case in spite of the title of this panel. I'm a political theorist by training with an interest in the intersection of liberalism and religion, and Catholicism in particular. And so perhaps a little bit like my predecessor in the talk earlier today, Professor Robert George, I'll provide a little bit more of the view from 30,000 feet in trying maybe in some ways to frame some of our discussion about this case. And I hope we'll be able to delineate some of the more what I regard as systemic challenges to conscience than those that might typically come up when one discusses particulars of a case. So a case such as the recently argued Hobby Lobby case pits oft-times conflicting claims of compelling government interest on the one hand and conscience or religious liberty on the other. And I'm sure, as we'll hear about more in some of the other presentations, these claims of conscience and religious liberty were given strong legislative protection with the passage in 1993 of the Religious Freedom Restoration Act, or RFRA, in which government was barred from placing a substantial burden, in the language of the act, on religious exercise unless government could prove that there was a compelling governmental interest justifying that imposition, and that the burden was achieved in the least restrictive way possible in order to advance that interest. And on these grounds, many who have been following the case, and even those who paid close attention to the oral arguments, believe that Hobby Lobby may ultimately prevail. Some of the debate will also be over whether or not a corporation can be thought to have a religion, but that may be a question that that I won't be addressing here. However, RFRA and constitutional law and the constitutional tradition regarding religious liberty, and I would submit even ultimately the Constitution itself, certainly as it has been construed, implicitly understand conscience in a way that ultimately, I would contend, make it increasingly likely that we will see more instances in which compelling government interest takes a direct aim at religious liberty, particularly in areas relating to contraception, abortion, gay marriage, and so on, even, perhaps paradoxically, when conscience is invoked as a protection against such government interest. This is, I want to argue in a very brief period of time, because the implicit understanding of conscience, both in the law and in society today more generally, is understood to be a privately held set of views or beliefs, the content of which the government and others are officially to be indifferent toward, unless, in the case of the government, one, it disrupts public order, or two, it comes into conflict with that compelling government interest. This dominant liberal understanding of conscience reduces conscience then to a form of private subjectivity, the views of each individual that can in some ways be objected to or confronted, except where it disturbs public order. And ultimately, I would contend, makes precarious the defense even of this form of conscience itself, as it itself underlies the growth of government and accompanying claims of compelling government interest, in order to expand subjectivity, particularly in recent times, subjectivity located in the self-ownership of our bodies, and especially in the sexual realm. Now, the classic articulation of this liberal understanding of conscience, Professor George talked about John Stuart Mill, but I would locate this in the thought of John Locke, particularly in his letter concerning toleration, another text many of you may have read. Conscience as belief is the purview of the individual, as Locke says several times in that work, quote, "The principal and chief care of everyone ought to be his own soul first, and in the next place of the public peace." Belief is ultimately a matter of the individual and the individual conscience, and should stop at the boundaries of the self in the name of public peace. Locke's notion of conscience is ultimately rooted in his understanding of each individual as self-owner, not only possessing the right, as he put it, to dispose of his person and property as he wishes, but also as the right to believe as he wishes, as long as it does not disturb the public peace. The state comes into existence in part, and indeed in Locke's telling in significant part, to safeguard that peace, indifferent to the content of individual belief, but determining when necessary whether manifestations, particularly outward forms of that belief, may disturb the public peace. Conscience is thus defined as individual, private, and based on the implicit epistemological assumption that agreement between different parties and different beliefs is finally impossible. The only way we can get along, modus vivendi, is toleration, the minimum agreement that we agree to disagree. Now, this understanding of conscience, which should be probably, I would think, familiar to all of us, stands in direct contradiction to the original understanding of conscience, certainly as it was conceived in the Catholic tradition, from which it was originally took shape and form. In fact, conscience in this original understanding rested on two fundamental ideas that are directly rejected by Locke's understanding and exist in contradiction to those. First, conscience is the faculty by which we are oriented toward and are thought to be not only oriented, but oriented to assent to the truth, an objective truth, not merely my truth or a personal set of beliefs or opinions. As it was articulated and often quoted from the Vatican II document, Pastoral Constitution on the Church in the World, which echoes the long-standing Catholic understanding of conscience that stretches back to Aquinas, if not earlier, and I quote, "In the depths of his conscience, man detects a law which he does not impose on himself, but which holds him to obedience." We don't make up the law. "Always summoning him to love good and avoid evil, the voice of conscience can, when necessary, speak to his heart more specifically. Do this, shun that. For man has in his heart a law written by God. To obey it is the very dignity of man. According to it will he be judged." Now, in 1991, the Cardinal Joseph Ratzinger, who became Benedict XVI, delivered a lecture in Dallas, Texas, entitled "Conscience and Truth," which has now been published as a book called On Conscience, and articulated the view, as one might expect, that the Lockean or liberal understanding of conscience is in fact in direct contradiction and repudiation of this understanding of conscience that derives from the Catholic tradition, that it is rooted on and dependent upon a presumption of relativism, and so ultimately isolated subjectivities hold views that are a result of contingent and ultimately incommensurable views and beliefs. This is what Ratzinger had to say in 1991. Conscience, by this view, the liberal view, does not open the way to the redemptive road to truth, which either does not exist or, if it does, is too demanding. In the view, again, of the liberal understanding of conscience, it is the faculty which dispenses from truth. It thereby becomes the justification for subjectivity, which should not like to have itself called into question. Conscience here does not mean man's openness to the ground of his being, the power of perception for what is highest and most essential. Rather, it appears as subjectivity's protective shell into which man can escape and there hide from reality. This is liberalism's idea of conscience, end quote. So this is the first understanding that's contradicted in the Lockean understanding. Secondly, the original Catholic understanding of conscience was not merely based in individual belief, the will to believe, as William James termed it, but rather formed in and by people's participation in community, and community in the broadest sense, including those who one lives with now, but also the past, tradition. Again, we tend to think of conscience as often being arrayed against some kind of authoritative tradition coming from the past. But by this understanding, in fact, conscience is formed in community. Again, Ratzinger stated as follows: "Conscience is a window through which one can see outward to that common truth which founds and sustains us all, and so makes possible through the common recognition of truth the community of needs and responsibilities." End quote. The orientation toward truth is one that we both learn from and with others, ultimately with the aim of sharing in that truth in this common recognition. Conscience is thus not a carapace or a shell behind which we protect our unbridgeable differences. It is the faculty that constitutes a bridge that is thought to be crossed together in community toward the truth. What Ratzinger then keenly discerned was that it was the liberal claim about conscience as mere subjectivity that led not to diversity, but to a profound kind of conformity. And I quote again, "As the mediating value between different subjectivities, social conformity, in the form of the way in which this liberal conscience would be directed, is intended to make living together possible. The obligation to seek truth ceases, as do any doubts about the general inclination of society and what it has become accustomed to. Being convinced of oneself as well as conforming to others are sufficient. Man is reduced to his superficial conviction that the less depth he has, the better it is for him." As he powerfully concluded this section, quote, "Conscience is degraded to a mechanism for rationalization." Now, as this mechanism has become dominant, and I think it unarguably is in our society today, and that the only basis for social cooperation, and I put that word in quotes, can now be understood to be the agreement to disagree, toleration, in which any and all differences lodged in the individual are ultimately cannot be subject to any kind of scrutiny. this prevailing view becomes actively hostile toward the original understanding of conscience. Since the view itself cannot accept or tolerate, what it cannot accept or tolerate is conscience as the demanding orientation toward truth based not in the individual, but in community. This view must be eliminated and will be construed as a compelling government interest requiring the state's power to achieve this end. The propping up of self-ownership will become increasingly the project of the modern state, encompassing both the economic realm, in which property ceases to be considered in terms of its relationship to the good of the community, and in the biological realm, in which our self-ownership must increasingly take the form of biological control of self and body and the elimination of any unchosen relations, and hence why we're seeing such a rise of a kind of agenda in birth control, abortion, etc., as well as remaking all of those relations that we do not choose according to our will, but according to nature, which I think underlies the rise of the agenda of gay marriage. What Ratzinger most deeply recognized was that the embrace of conscience as subjectivity would ultimately jeopardize conscience itself. Subjectivity would become conformity, the very absence of independent judgment. Everyone must agree that there is no truth and no community, that there is only subjectivity, but that this demand would ultimately contradict subjectivity itself, replacing groupthink and ultimately government coercion for independence. Conceived of as subjectivity, Ratzinger concluded liberal conscience does not liberate, but enslaves. Our legal system enshrines this concept of conscience in according to the liberal understanding as subjectivity. It presumes the absence of potential agreement about truth, only that we can be engaged in articles of peace. In so doing, it has actually fostered the conditions for the crisis of conscience. And the greatest irony today, then, is that this doctrine of conscience is that to which our law and our lawyers must, and the only avenue to which they can appeal to prevent the aggressive expansion of the state against religious liberty. But even if this appeal to conscience wins, the basis for conscience itself ultimately loses. Thank you.
Should I start? All right.
12 minutes.
All right, thank you very much for having me here. It's an opportunity, I think, to help try to clarify what was just referred to as the liberal position on some of these issues, because I think there's a different kind of foundation for the basis of toleration, and my remarks will touch on that. So I want to begin. So I have a law background. I clerked. I'm interested in these legal issues as well, and I think there's a host of really interesting ones that I assume the rest of the panel will get into. I just want to briefly highlight a couple of them because I think they are interesting. So first, are corporations persons under RFRA? That's a really interesting question. Do corporations get free exercise protection? Does it matter whether they're closely held or not? Is commercial activity more generally covered under free exercise? These are all sort of really foundational issues to this case, and in many ways, ones that the Supreme Court, anyway, hasn't grappled with directly in the way that they'll have to in this case. More generally, what are the relationships between the statutory rights to free exercise provided by RFRA and the constitutional First Amendment rights? How will those intersect? How will the court decide things? I'm interested in this sixth question. How do we identify what a corporation believes? So that's an interesting evidential kind of empirical question. How do we figure out what a corporation believes if we want to acknowledge that they're persons? I might be open to acknowledging that they're persons, but then we will have this question to answer, particularly if we're going to look at the sort of test for substantial burden on religion. So the test under Thomas and Lee, this is pre-RFRA, but the basics still apply to RFRA. This is actually taken from the respondent's brief. So first we identify the religious belief in question. That's the first stage of the inquiry. Then we determine whether this belief is sincere. That's not contested in this case. And then third, we determine whether the government places substantial pressure on the religious believer to act contrary to those beliefs. So then in the respondent's brief, they say the purported belief in Hobby Lobby is that providing insurance coverage for contraceptives that could prevent a human embryo from implanting in the uterus, they themselves would be morally complicit in the death of an embryo. That's the belief. And it's attributed to respondents as a collective. without fine-grainedness with respect to whether it's the Greens, the family members involved, or Hobby Lobby Incorporated or Mardell Incorporated. So it might be clear that the Greens believe this claim here on the handout, but I think we would want to have some sense of how we're going to get evidence that the corporation believes this. So in philosophy, there are hard questions about the metaphysics of belief. What is a belief? How do we know when someone believes something? What kind of evidence do we have? We might just take testimony in a lot of cases to be good evidence that some person believes something. But a corporation can't offer testimony in this sense. So there's interesting philosophical puzzles here, but I'm not going to talk about those. I think in many ways, focusing on the legal issues of this case too early will distract from the big picture. In particular, many people have made this kind of argument that focusing on the law often distracts us from focusing on the moral issues at play in the case. So we get bogged down in issues about predicting what the court will do, or looking at precedent, or looking at sort of the interstitial sort of issues that we haven't squarely seen decided, but can kind of read the tea leaves. Focusing on statutory language and statutory history. And I think in general, we can be distracted by our personal politics and what we hope for in terms of the outcomes, just from a sort of pure policy perspective, rather than focusing on the background underlying moral principles sitting behind the views. So obviously, all those other things are important, and they affect the facts on the ground. Who's actually going to have their rights trampled? That kind of issue. So obviously, they're important, but I think we should ask not just what the law is, but also what the law should be. And that's taking us out of the normal realm that you engage in law school, at least for most jurisprudential views, where there's a distinction between what the law is and what it morally ought to be. So in particular, it takes us out of the narrow question of what U.S. constitutional law requires in this particular case. So if we are designing a society from scratch, how would we set it up? How would we want the free exercise, freedom of religion kinds of principles to be implemented? What would we want? Okay, so that's the question I'm going to talk about. And what I want to suggest is it's not just about personal morality. Sort of the question, is it morally wrong for me to use a certain kind of contraception? That's a first-order moral question I might ask myself. But it's questions about political morality. So what kinds of legal and political institutions and rules ought we to have, particularly given these other requirements that we think apply: liberty, political legitimacy, political equality, and justice. Okay, so I want to get into that issue a little bit. So I think it's a deep problem. I do not think this is an easy case. I think the issues it poses are actually sort of deep, philosophically hard problems that have really been what political philosophers have been struggling with for the last several hundred years. So what I'm going to do is identify a number of claims, a number of principles. Some of these are sort of stated empirically as something that could be true or false. Others are sort of normative claims. That'll become evident as I go through. So the first one, moral agency. I use that label. We could have used something else. That's the idea that each of us has some sincerely and strongly held beliefs and values, and we want to be able to live a life that is in line with those beliefs and which exemplifies those values. That's true for all of us. All right? That's a really important fact. And importantly, in response to Professor Deneen, I don't think anybody thinks that the beliefs they hold and the values they ascribe to are purely subjective, purely relative. So this is the kind of thing that, as a philosopher, I try to dispel in Introduction to Ethics. All the first-year undergraduates come in, and they're all sort of quasi-relativists. Oh, it's just my opinion. And philosophers hate that talk. So once you move into the philosopher world, there are people who defend moral relativism, but it's a very sophisticated philosophical position that very few people subscribe to. Most people who do philosophy are realists. Certainly most people who do moral and political philosophy. There's this branch called metaethics that tries to pose these questions in a purely metaphysical or epistemological vein. But that's sort of the minority view. So I think that the liberal position on these issues is one that is objective, that people see as objective, as being about the world. Now, we disagree. That's what makes us in conflict. But I think we all have these beliefs that we believe to be true. So a couple things follow from moral agency. So first, we want to be able to do certain things and not be forced to do other things. So we want this. So including, we want to be able to believe certain things and not be forced to believe other things. So Brave New World, 1984. I'm also in a bioethics department. We could do all this stuff with technology to alter your beliefs. Those we would see as very intrusive. Similarly, we don't want to be forced to say certain things or deny certain things, as has happened throughout human history, where people were forced to attest to things that they didn't believe. So these are all under the subheading of doing things in general. But there's lots of other things we want to be able to do. We want to be able to marry people if we think that's what we want to do. We want to be able to go where we want to go. We want to be able to work in the kind of job we want to work in. We want to be able to go to the kind of church or religious institution that we want to go to. These are all activities in the world that we want to do that follow from our commitments, our beliefs and values. And I think that's true for everybody. So some additional things to note about this. I think in the background there's something like an authenticity requirement. These have to stem from you in some sense. That doesn't mean that they're just yours and they couldn't be shared or part of a community or a tradition, but they have to be in some sense reflectively endorsed by you. If they were just implanted in you, that's not going to be the right kind of thing. So then second, there's I think a core periphery distinction that's really crucial. So not all of my beliefs and values are equally important to me, nor is it equally important to be able to speak about or act upon all of my beliefs and values. And that's true for everybody, whether they're religious or not. There's a core periphery distinction. I actually think that distinction is the morally important one that's connected up with moral agency. So for this case, the commercial, non-commercial distinction, which I mentioned at the beginning of my remarks, I think that's important only if and to the extent that it aligns with the core periphery distinction. So maybe our commercial activity is more on the periphery of what we do. But if it's not, if it is part of who we are, I don't think there's any reason to treat that as less serious, as those beliefs and values as less serious. Indeed, many of the big issues of our time have to do with being a reflective consumer and thinking about the ways in which our commercial values are altering the world. Similarly, the religious, non-religious distinction, which is really important, obviously, in U.S. law and throughout human history, I think it's important only if and to the extent that it aligns with the core periphery distinction. In this way, I think I agree with Professor Deneen. Sorry, I don't know how to say your last name.
Deneen.
that it actually does really matter that these are beliefs that you hold and that are in a certain sense objective. That's the kind of thing that matters, that you take them to be objective. Sorry, I should be precise. So I think it doesn't matter whether they're religious or not for this important connection with our deep core beliefs and values. So I think this is controversial, but I think it's correct. So we want all of this stuff. Now, page 3 of the handout. We want all this stuff, but we also arguably have a strong moral claim to this. Okay, now that moral claim has different derivations. People in philosophy have argued for centuries about the basis of these kinds of moral claims, the claim to moral agency, the claim that I call moral agency. So one, it might be based on our capacity for agency. We're a special kind of thing in the world. We can form plans, have values, and try to live up to those values, unlike, say, tables and chairs. And that's what gives us a certain kind of moral claim that tables and chairs, say, don't have. It might be because we have some kind of status as moral persons, where the details of why we have that status has to be filled in, and it might include things like chimpanzees or pigs or cats, or it might not, depending on our view of moral status. Might be because we are creatures deserving of dignity or respect. Might be because we're human beings. I want to leave that open. Okay, so the important thing is moral agency requires, or at least on the liberal, a certain kind of liberal picture, requires not just freedom from interference, but also possibly redistribution of resources and support for our basic capacities. So education, food, shelter, health, real choice in terms of work, leisure, and community. To actually be able to live in line with our beliefs and values, we might require some things from the world. We don't just come here sort of fully created. I actually think community is an important part of that. Okay, so now on to the other claims. Okay, disagreement. Within our actual society political community, members of our community do not all share the same beliefs and values. There's sharp and significant disagreement about these matters, and all of us take ourselves to be correct about something of deep moral significance and something that matters to our core set of beliefs and values. So we might imagine a community that we create that doesn't have any disagreement, but that's not the actual world. That's not the actual political communities we live in. Additionally, children will always pose a problem to any sort of homogeneous community because they might depart from the values of that community. So thinking about exit and movement. Then conflict. So our disagreements and our beliefs and values do, or would at least if nothing's done, lead to significant practical conflicts. These disagreements aren't idle. They're not academic in the pejorative sense. They actually will lead to real-world conflict if we don't figure out what to do about them. And then community. In order to live together peacefully and productively, so capable of engaging in joint endeavors and responding to problems that face all of us, problems that generally require kind of collective action effort, To do this, as members of a community, we must find some way of reconciling moral agency and disagreement and conflict. All right? So these are the big background moral issues. And then further, moral constraints. There's constraints on how we go about doing this reconciliation, and those derive from moral sources, perhaps from the considerations that animate moral agency, or perhaps from some independent source. So just quickly, I think applying this to the Hobby Lobby cases. So I think the question we should be trying to ask is, what is the real burden in this case? What is the real burden on moral agency, the kinds of deep moral value commitments, moral belief commitments that people have? So the Greens or Hobby Lobby or the affected employees. That's the kind of question we should be asking. How core is this to what they're doing? And then we have to think about community and the place of democracy here. So we could imagine exceptions to general laws based on considerations of moral agency, but these might come at a high cost to community in various ways. They might undermine our ability to actually live together. So anytime we accommodate, there's always a worry about burden shifting, and there's a worry about the sort of fairness of that burden shifting given the background democratic compromise. All right, so given all of this, it seems a small burden, frankly, in this case, and perhaps an excessive remedy. So it's a small burden because it runs not through a direct requirement on the Greens or on Hobby Lobby to do X, but through something like X, which they find to be objectionable, but through a complicity argument, that they'll be complicit. But that's true for almost everything we do in any kind of market or communal activity. We're all complicit, in some sense, in helping each other do all kinds of things we find objectionable. So they don't want to cover insurance, but they're paying a salary. What's the complicity difference here? Now, we're not supposed to scrutinize that under the law. That's getting into the details of their belief. But I think for the moral question, that's a really vital question. All right, so the last thing, I note here several Supreme Court cases, including opinions by Justice Scalia in Employment Division versus Smith, and recent opinion, Cutter versus Wilkinson, that sort of brings out this basic view of the world. That we all are going to burden each other all the time, and that we have to put community as a centerpiece and think about that value in addition to the moral agency value. All right, I'll stop there. Thank you.
So thanks so much for having me. So I'm a litigator at the ACLU, and we've been involved as amicus in these cases, both in the for-profit cases and in the nonprofit cases, including Hobby Lobby. So I'll just take a step back and talk a little bit about what the rule requires and some of the legal arguments. So the contraception rule requires employers to cover contraception as part of a comprehensive health package. It's part of the Affordable Care Act, and it's part of a preventive services requirement that includes a number of things that are specific to women's health issues, including issues related to pregnancy, domestic violence, screening and care, and things like that. And the idea of the Women's Preventive Health Services Package was to eliminate the cost disparities that women face with insurance. And so it was designed to ensure that women had health care that they have historically not necessarily had in their insurance coverage. And to eliminate the disparities in costs between men, women, and insurance plans. The Affordable Care Act, this particular rule, does not apply to churches. So houses of worships are completely exempt from covering contraception at all. Nonprofit organizations that have a religious objection to providing contraception can take advantage of what's called the accommodation. The federal government has allowed nonprofit organizations with a religious objection to providing contraception to fill out a form, send it to their insurance company, and then the insurance company will provide the contraception directly to their employees. And then the third category of employers is for-profit employers, and that's what we're talking about with Hobby Lobby and Conestoga Wood Specialties, the two cases that reached the Supreme Court. We'll put the nonprofit cases aside for a minute, but the issue of the accommodation may come up later in some of our discussions. So there were a number of these cases filed, and there was a circuit split. The Third Circuit in Conestoga found that companies lacked the ability to bring a RFRA claim, that they did not have the religious liberty that was implicated by RFRA, and because the contraception rule runs only to the company is the only one required to provide contraception, that the owners of the company were not, their religion wasn't burdened. Hobby Lobby came out of the 10th Circuit, and that the court found the opposite in terms of the threshold question of whether companies have religious liberty rights, and then went on to consider the other aspects of the RFRA test, which I think other folks have talked about before on the panel, and you probably also know that the question is whether religious beliefs are substantially burdened. And so in that the inquiry, even though sincerity isn't necessarily something that should be scrutinized by the courts, courts can assess whether there is a substantial burden on an individual's religious beliefs. And even if there is a substantial burden on the religious beliefs, is there a compelling government interest that justifies that burden? And is it narrowly tailored to further that compelling government interest? And the 10th Circuit went through this test and found that RFRA was likely violated. And there are a number of other courts that have also considered these issues, but these are the two cases that come to the Supreme Court. Argument was heard on March 25th, and it was an intense day of questioning, and I think no one really knows the outcome. Obviously, we never know what the Supreme Court's going to do, and I'll talk about some of the possible outcomes at the end. But I just want to talk a little bit about some of the aspects of the test, and one of them is the substantial burden question. And I think, as Professor Guerrero said, that there is this question of whether there is a substantial burden on the company's religious beliefs when the connection between the religious beliefs of the owner and providing contraceptive coverage is very attenuated, and it really is the same thing as paying salary. There is providing a comprehensive health package that some employees may use to obtain some service that the employer disagrees with cannot be a substantial burden on the religious beliefs of the company's employers. But even if it were, there is a compelling government interest that justifies any sort of burden. And that's where the ACLU has focused its amicus brief in the Hobby Lobby cases. And we talk a lot about the history of the use of religion to justify discriminating against others and taking away benefits or denying services from others. And there was a time in this country's history where religion was invoked to justify segregation and resist integration, and it wasn't really until the civil rights movement that things started to change. And it's really interesting when you go back and look at and read some of these cases, and you see the courts justifying racial discrimination based on religious beliefs and the biblical belief, as put forth by some, that the races should be separate and distinct. And also, too, with respect to women's rights, there were a number of religiously affiliated employers that were trying to deny women equal pay based on their belief that under the Bible, women should be, men should be the heads of household, and men should be paid more. So we've gone through this history in our brief, and we've talked about the ways in which we now, as a society, and our courts have rejected the use of religion to justify discrimination, and that's exactly what's at stake here. The contraception rule is designed, as I said at the outset, not just to eliminate the disparities in healthcare costs between men and women, but meaningful access to contraception for women means that women will be able to make decisions about whether and when to have children, which in turn allows women to be equal participants in society. And there are a number of studies that we cite in our brief in terms of the advent of contraception allowed women to go to graduate school, go to college, enter certain professions that were previously foreclosed to them. Contraception was actually, it can be attributed to a reduction in the wage gap between men and women. And so meaningful access to contraception, taking away cost barriers, which is exactly what the rule does, allows women to have meaningful access to contraception and allows them to be equal participants in society. And so and so what's at stake here is whether the imposition of another religious belief or someone's religious beliefs could be used to take away benefits or services from another. And a lot of the cases that Professor Guerrero cites are incredibly important and also dovetail on another amicus brief that was filed by Professor Fred Geddix of BYU Law School, who talks about this issue of using religion to deny benefits and services to others and how that would actually cross the line between accommodating religious beliefs into the realm of the Establishment Clause. And if the court were to grant an exception to a for-profit company like Hobby Lobby, that the court would be crossing that line between accommodating religious beliefs and establishing religion. I think that the arguments were very interesting, and I think that no one really obviously knows what's going to happen. There were some of the questions asked by Justice Kennedy I think were completely on point. And at one point during argument he asked, and obviously I'm mentioning Kennedy because we all look to Kennedy, we all assume that he's going to provide the fifth vote, one way or the other. And he said at one point, wouldn't this be a disadvantage to the employees if you were to deny the contraceptive coverage? And does religious liberty just get to trump? Is that how it works? And I think I hope that was a rhetorical question because I think that's exactly what's at stake here. Another question he asked was about whether there was a substantial burden on religion at all, because Hobby Lobby doesn't have to provide health insurance at all. Hobby Lobby could choose not to provide health insurance and instead pay a tax that would be less than health insurance coverage costs. So there would be no burden on their religious beliefs. And Justice Kennedy said, picked up this point and also asked some questions on that as well. So we find out, I think, at the end of June how this case comes out, and the challenges to the nonprofit accommodation. Many religiously affiliated nonprofit organizations were perfectly happy with the accommodation, including the Catholic Hospital Association. But there are some religiously affiliated nonprofits who have filed suit and said that even filling out the form and sending it to their insurance company is a substantial burden on their religious belief. And those are also working their way up at the courts of appeals, so I think we'll also see those cases coming to the Supreme Court unless the decision in Hobby Lobby speaks to how those cases should come out too, and I just don't know the answer. But one of the questions could be is whether the Supreme Court would extend the accommodation to the for-profits, but whether the for-profits would even want that, because a lot of the same people who are behind the challenges to the for-profit aspect of the rule are also behind the nonprofit challenges as well. And a decision for Hobby Lobby could really open the doors to the Arizona type bill that we saw Jan Brewer veto in Arizona. And the drawing the connection between the two, I think, is incredibly important, because that bill would have allowed private entities to refuse to serve gays and lesbians. And yeah, actually, it could have. So I think there's a real concern if the ruling for Hobby Lobby, although not directly connected to that, jurisprudentially that's a different question, that there's a real concern that a decision for Hobby Lobby could add fuel to the fire of that argument. And to add fuel to this fire that in the modern era where we have rejected, and that's the idea that religious liberty can trump and religious liberty can be used to discriminate against others.
My name is Jordan Lawrence, if you've forgotten, and I'm an attorney with Alliance Defending Freedom. We represented Conestoga. And I also just want to point out that you have before you two attorneys that actually earn a living doing constitutional law, Ms. Amiri and me. And that's why we all went to law school, but many of you are not going to be able to do it. But if you just want career advice, there's two of us here, and even though we disagree on these issues, I do want to say it's a remarkable thing to be able to work and really be totally engage and agree with what you argue. And I'm obviously a lot older than her, and I've seen many ACLU lawyers over the years, and even though I disagree with them, I respect the fact that they're motivated by promoting what they believe, I think wrongly, but still motivated to believe in a higher purpose with all of that. I want to give to you, so I've been around long enough. I was in the courtroom in 1990 when they handed down Employment Division v. Smith. I was also, although I was on the periphery, involved in all the discussions when Congress passed RFRA in 1993 and President Clinton signed it into law. So I want to give you kind of an intuitive, maybe Twitter-like understanding of how religious liberty operates. And I think I can do this in less than 2 minutes here. I got my little, thing going here. So, and so you can understand what's going on here. Okay. I want to talk about 3 cases. One of them's made up. The first one's made up. There's a guy who believes in Aztec religion, and he believes in human sacrifice. And he says, I should not be convicted of murder because I was being sincere in my religious beliefs. Intuitively, we believe that guy should lose. Then here's a case over here. And this is an actual case that happened in 1979 at a public school in Illinois. They required all the kids in high school to go to co-ed gym class and wear white t-shirts and red gym shorts. And girls from the young women in the Pentecostal church asked if they were going to be in co-ed, if they could wear longer sleeves and pantaloon type, rather than the short shorts. And the school said no and suspended them. And it was based on their religious beliefs about modesty. Now, I think intuitively say, the governmental interest seems pretty trivial, they should win. Then let's put a case in the middle. The government says, we want to put orange triangles on the back end of slow-moving vehicles so people that are driving faster don't crash into the hay wagons or whatever. Well, then here's the Amish out in Lancaster County and other places in the United States. They believe the fluorescent orange is like flamboyant and prideful and calls attention to them. So they get arrested for not having these orange triangles. And so the Minnesota Supreme Court said, the governmental interest is obviously if traffic safety is important. Is there another way to implement it? And they said, you know what? Do you have an objection to putting reflective gray duct tape on the perimeter of your buggy and hanging oil lamps? And the Amish say no. And then they get some experts. Does that have more or less the same effect as an orange triangle that you can see the vehicle? And at least the Minnesota Supreme Court said yes. So now, okay, so the Aztec guy should lose, the young women in the gym shorts should win, and that the one in the middle is, can you figure out a way to do the governmental interest in a way that resolves the conflict? Now, all of that intuitive understanding said, let's come up with this 4-part test of the sincere religious beliefs, substantially burdened. Is there a compelling governmental interest that's done in the least restrictive means? So what they're trying to do is separate the wheat from the chaff, the sheep from the goats. So like if somebody comes in and says, well, I want to discriminate against black people, well, they would lose. And then it would also mean if somebody said, well, young woman in Illinois, we know you just want to wear longer clothes. But in the past, people, white supremacists, have invoked the Bible to say that blacks are inferior. So because they might do that, if you win, you either have to be suspended from public school or put on the white shirts and the shorty red gym shorts. People say that's ridiculous. There's like, we have some capacity to understand nuances and differences between all these cases. So that people that have extreme cases lose, and people that have more moderate ones or ones where there's a least restrictive means wins. So I want to point to you, because I feel that if we just think religious liberty started about a month and a half ago at the Arizona legislature, and the second thing that's ever happened in religious liberty is the Hobby Lobby Conestoga cases, you get this kind of distorted view. During the Vietnam War, do people who are pacifists, could they be exempted from the draft? Now, we didn't say, well, because, in the past, white supremacists have said and quoted the Bible to be black, so you have to go serve in the army. That we'd say, no, there's something else going on here, and so we give them exemptions. So I just want to say This applies to all sorts of situations, and to limit this to just say, these horrible floodgates are going to open, I just think is just not going to, is not an accurate picture of what's going on. So I just want to talk about, so just with that as a framework, I'm just trying to rehabilitate in your minds that being for religious liberty is something good. Okay, what about, can corporations assert religious liberty? A corporation can't get circumcised. You can't baptize a corporation, but we say that corporations have freedom of press rights. The Pentagon Papers case was brought by Washington, the Washington Post Incorporated. When New York Times got sued for libel, got sued for libel by the Alabama segregationist sheriff, they didn't say corporations can't assert freedom of speech and freedom of press rights. They allowed them to do it. And then plus, most religious groups in the country are corporations. And we don't have any trouble saying that a synagogue or the Mormon church or the Catholic archdiocese can be incorporated and actually function in religion. There's nothing alien about the concept of corporation. I mean, if Starbucks says we're going to, we feel a moral responsibility to pay fair trade for coffee because it's the right thing to do, we accept that. Now, I don't think this is going to happen, but if the Starbucks board of directors said, we're going to pay fair trade because the Bible says so, I don't think that would render it any less protected, or that there's some sort of moral action that's being implemented by the thing. So I just think that it's kind of not an analysis of what's going on. I mean, if the Department of Justice went after a corporation for paying bribes to somebody, now the corporation get in trouble, but I don't think the CEO could say, hey, I didn't pay the bribes, the corporation did. You know, that there is a way where we view the human agents that operate a corporation, give it direction. If it's, we're going to open stores in Delaware, or we're going to do something that we think is morally right, we're going to close on Sundays, or we're going to pay extra, or we're going to be careful about how the clothing is made in the factories in the third world, that I just think that that's just intuitive. Now, the RFRA can be, the Dictionary Act says that persons include corporations, so it applies to corporations. I just don't think there's anything bizarre about that, and I also don't think we're going to be opening the floodgates when corporations are, because this is not, we would have already seen, RFRA's been on the books for 21 years. We would have seen the bizarre cases, the floodgates opening, all these things happening that would make distortions of the law, and they just haven't happened because the four-part test does a pretty good job of sorting out the wheat from the chaff in these kinds of cases. So let me just see how much time I got left here. So, or should I, how much time do I have left? 3 minutes? Okay, I will talk fast. Third-party harm. I think third-party harm, let me just talk about this for a moment, is third-party harm is definitely a relevant interest, but it's not an absolute trump card in these kinds of situations. I think it goes to the compelling state interest, but I think it's just a factor to be considered. So, for example, and there's these trade-offs and balances in all sorts of cases. So in New York Times versus Sullivan, the white sheriff in Alabama felt that he was being libeled by the falsehoods that he alleged were in the ad that was in the New York Times. And the Supreme Court basically said to him, you have to suffer a certain level of falsehood before we're going to allow you to bring a legal action against the New York Times. So the New York Times, even though its speech was affecting a third person, wasn't an automatic trump card. Even in the religious liberty context, employers had to start paying extra unemployment tax because the people that objected to working on Saturdays and were fired got unemployment tax. So there was a harm to a third party. Judge Jeff Sutton at the Sixth Circuit, when he has, there are some death penalty states with the death penalty in the Sixth Circuit, if a law clerk has a religious-based objection to working on death penalty cases, he exempts them. He doesn't say either do them or you're fired, but then it also puts more burden, if they have a lot of habeas petitions, for example, for death penalty cases, on the other clerks who don't share a conviction about opposing the death penalty. Title VII, there's a reasonable accommodation requirement that employers are supposed to do if a religious person, doesn't want to work on his or her Sabbath, etc. That puts a burden shifted on other people. Now, the issue might be, is the burden significant enough that Hobby Lobby and Conestoga don't win? But it's not, whistle blows, third party affected, you lose. I think that has not been the law, and also doesn't really comport with reality about that sometimes people shift to put out these so that we can share these burdens. I also think what the least restrictive means is that when we talk about women's access to contraceptions and to abortion, I think that one of the things to keep in mind is the huge number of corporations that have grandfathered plans. So there are many, many women that are not being required, who are not having access because Congress never wrote it into the law, and is basically allowing them to be exempted, as well as religious nonprofit groups, which shows that the people at the Department of Health and Human Services understood that there was going to be some religious objections. So they exempted some people about this. They didn't say, this is so important, of such magnitude, that this is the only way to put out the access to birth control, that we're going to impose it across the board on all employers. So when you see large swaths of employers being exempted from the requirement, I just think it undercuts. Also, this is an issue of who pays for it. Is it a direct payment by the employer, or can it be provided by government programs that already exist, for example? And if you're not really buying into that, just think of this. What if the requirement was the federal government said all employers have to pay for the private school tuition of their employees? Now, would that be taking away a right? Would that affect third parties? But, well, I guess all that would apply, but you would certainly see why employers would object and say, you pay for it out of your salary, but we're not going to have, but there's something objectionable about having the government forcing employers to pay for it. Thank you very much.
So now we're going to open it up to some Q&A, and being a modern building that that this is cased in, we have microphones right here that are working. All you need to do is push the top button, depress that, and that'll activate your microphone. But we have about 25 minutes for Q&A. So.
This question could go to Mr. Lawrence or Ms. Amiri. I guess my question is, when people say, how can a corporation practice religion? I was just wondering, in Pennsylvania and a few other states, we have what's known as a B Corp, which can be incorporated for a specific it can be a for-profit corporation, which can have a public motive, which explicitly notes religion as one of those possible purposes. So I was just wondering if any companies have been trying to do that in the context of religious liberty.
I'm trying to find the place in Pennsylvania law that basically says a corporation can be set up for all lawful purposes. I just think it's very unusual in this day and age for corporations not to be set up with a very general purpose in their articles of incorporation. And I don't think that this case is going to be decided, if this is what you're asking, on is this within the purpose of Hobby Lobby or Conestoga, because I think it clearly is within how their articles of incorporation are drafted.
I agree that's not how the case is going to be decided.
I'm intrigued by the compelling government interest prong of the test, and I think you've made quite clear that from the ACLU's perspective, a woman's access to contraception and abortion is compelling. But of course, it's a government interest, it's not the ACLU interest that's being measured here. And as I understand it, Kennedy was asking questions about how this provision got into the law and was very critical of the fact that Congress did not create this list of required drugs, contraceptives, abortifacts, or whatever. Rather, it was created by an expert panel within Health and Human Services, adopted without notice or comment as a temporary rule, and wonders whether that goes to how compelling of a government interest it really is. If the democratically elected Congress did not include it in the law as a requirement, does that undercut in some fashion the argument that it's a compelling governmental interest as opposed to an ACLU interest?
I don't think it undercuts the argument at all, and I will say that it's not just the ACLU who says it's a compelling government interest. It's the government as too. If you read the government's brief, it's not just the ACLU standing alone in this. I do remember Justice Kennedy's questions on this front, and I wasn't sure exactly what he was getting to. I didn't know I couldn't understand if he was thinking that there was some sort of separation of powers argument to be had. But it is correct that the contraception rule is a regulation, and Congress, however, passed the Women's Health Amendment that was specifically supposed to reduce some of the disparities in healthcare costs, and the regulation then furthers that. So I don't actually think that it really makes a difference that it's an executive agency that has promulgated this regulation in terms of whether there's a compelling government interest. I think that whether it's a regulation or a statute passed by Congress, there is a compelling government interest that can be asserted and has been asserted here, both in terms of women's equality and women's health. There's also, I'll just note that there's, on the women's health perspective, there are a number of amicus briefs, and the government talks about this as well, about the health benefits to women of meaningful access to contraception.
We were sitting very close together in the courtroom there. We didn't know each other at the time, though. And I agree that what Justice Kennedy was getting at was a bit confusing. I remember I was writing the notes, and I was thinking, like, okay, what exactly is he getting at? But I would say he was definitely not happy with the government's answer to the issue, and I'm not sure exactly what he is getting at, but it does seem to be something like, I mean, this is, for what this is worth, this is my interpretation of it, that he asked a question like to General Verrilli, these exemptions for the religious nonprofits, are they based on the Religious Freedom Restoration Act? And he said no. And now, again, this is my interpretation. What I think he was saying was like, wow, that doesn't seem like a very compelling state interest. And plus, what are you basing what is the legal basis for the agency, the administrative agency, to exempt religious nonprofits when you're just sort of like willy-nilly giving it to them and not giving it to others and saying, oh, we got a compelling state interest, oh, but it's not so compelling that we have to give it to religious nonprofits. And I think he was saying that's really kind of a confused thing, and how are we supposed to sort that out is, I think, what he might have been getting at with his comments.
With respect to the substantial impact issue, what are the specific contents of the actual form that has to be filled out by an employer, which directs the insurance company now to pay for that rather than them having to pay directly? And secondly, how does it affect the cost of the premium that has to be paid by the employer? Is it decreased, increased, not changed? How does that change? How does that affect it?
Well, just to be clear, the form, that's the accommodation for religiously affiliated nonprofit entities. So the for-profit companies like Hobby Lobby, they have to cover the cost of contraception. So the form is really with respect to the nonprofit entities that are religiously affiliated and are taking advantage of the accommodation. So just want to make that distinction clear. And the content of the form is one page. I don't have it memorized off the top of my head, but it says something along the lines that I have a religious objection to providing contraception coverage, which is probably likely precisely what the company did, the religiously affiliated nonprofit did even before the rule, to ask the insurance company to take contraception out of their comprehensive health plan. And the government has also recognized this in the promulgation of the rule, saying that this is communicating that to the insurance company is likely no different than what they did before the rule, because of the default to include insurance in contraception. And in terms of the premium, I don't know that this is a factual issue that's actually been litigated.
I think that is correct. And I would just add that the forms for the religious nonprofits, like the Little Sisters of the Poor case, one of the issues came up was, could the federal government grant that to the for-profit corporations that have similar objections, and then would the for-profit corporations accept that or not? And that kind of came out towards the end of the oral arguments.
But I certainly don't think that the premium is going to increase as a result of the contraception rule.
I actually have a question for Professor Deneen. It seems like from your presentation that no matter what the result, we all sort of lose at the end of the day because of our false conception of the freedom of conscience. Are you rooting for a particular side, and why? And do you think one side represents a particular danger, or is there a philosophical distinction between the two sides, such that you can distinguish between a side that you're rooting for versus a side you're not, or is it all sort of, we're all headed down a disastrous atomistic path?
Yes and yes. Thank you for that question. Well, I guess just in general, what I was trying to convey, and a lot of the things I've been trying to write and think about lately, is I'm certainly not the first person to talk about this, is to challenge the conception or idea that going back to thinkers like Locke and Mill and Hobbes, et cetera, that liberalism constitutes a kind of a neutral settlement between different people of different perspectives and views, and is neutral as to the sort of content of beliefs, and as long, again, as it doesn't constitute a public harm. And I'm personally more and more persuaded philosophically and also empirically that, in fact, this settlement itself contains a kind of set of substantive commitments, and that we're seeing many of those substantive commitments, particularly as regards the stress upon the priority of autonomy as the constitutive fundamental value of liberal societies. And so if your fundamental commitment isn't autonomy, what I was trying to suggest perhaps in a complex and philosophical way, if your fundamental commitment is not autonomy, you are likely to run afoul of a society that increasingly will forefront and indeed place the deepest value upon autonomy. I found the formulation that the community is the centerpiece, in a certain sense puzzling, but also revealing that the community is the centerpiece of the settlement, because in a certain way you're saying that the community, aka the nation or the government, becomes the insurer of our autonomy. And so it's an interesting conception of what community is, but it's certainly not community in the sense that we are not most fundamentally to understand ourselves as autonomous, independent human creatures defined above all by the kind of autonomy of our conscience. As to what I'm rooting for and whether I think that we're sort of doomed in the end, I'm very much hoping that the decision comes out in favor of Hobby Lobby and Conestoga, and I share the view of my colleague here to my left, right, I'm not sure, that it seems to me that even if we understand this case as involving a substantial government interest, it seems to me it's a very shaky argument that this is the least, this constitutes the least burdensome way in which to ensure this outcome. There would be other ways, I think this has been talked about by a number of people, I think people in this room, how this provision could have been covered in other ways without burdening places like these companies, as well as my institution, Notre Dame, and other religiously affiliated institutions. It seems to me that it was a particularly aggressive form of rulemaking that was intended in some ways to pick this fight. And I think there's actually a very deeply problematic and indeed very cynical way in which this was an effort to trump up the idea that this constitutes some kind of a war on women when in fact this could have been the same kind of provisions could have been fulfilled by other less burdensome means. So I'm actually of the view that I think the case should be a fairly easy decision. I'm sure it won't be, but I hope that it will be. But and here's, this isn't going to help the lawyers in the room, but maybe it helps the citizens in this room. I think we need to be extremely aware and conscious of the ways that the deepest presuppositions that seem to underlie, among other things, our understanding of conscience and of the liberal settlement, place a kind of finger on the scale. And that as I was suggesting, I don't think we'll be seeing that I don't think this is the last of these kinds of issues. And indeed, as in some ways what seems to me increasingly will be the role of government in some ways to become the insurer and in some ways the modern project of creating and extending this experience of autonomy, we can expect to see a kind of growing government power directed at that end and increasingly at institutions and communities that hold a different view of the human person. So I don't think this is an accidental kind of case. I think we can treat it as a case, and it's important to do so, but I think we need to see it also as part of a larger fabric. I don't know what you do with that as lawyers, but I do think there's, as citizens, we need to be aware of this kind of finger on the scale in our society.
I know nothing about philosophy, so let me...
I know nothing about the law.
Right, so here, let me share. But one of the things that, which I basically agreeing with one aspect of what you're saying, and this is my simple way of putting it, and you tell me if you think this is right or not. There is a balance between how you have community, like we're all in community, we got to all learn to get along, and then individual rights. And if you stress individual rights too much, it becomes like the legal equivalent of a Ponzi scheme. That somebody is going to, in order for somebody to get their rights to the fullest extent, others kind of get shortchanged in the process. And so that there's a level where the full extent of the, kind of the autonomy, self-autonomy, it only certain people get it, and everybody else has to sort of, serve them. And it's not like because you can't have everybody have self-autonomy at the same time. Somebody gets holding the bag like in a Ponzi scheme. So anyway, is that kind of like what you're saying?
Sure. I mean, the person who I think said what you're saying best was Marianne Glendon in a book written probably 25 years ago called Rights Talk, about the way in which rights talk acts as a kind of solvent to human communities and human relationships. It acts as a kind of wedge by which we, in some ways, separate ourselves from each other, expect certain kinds of entitlements without corresponding understanding of duties that accompany those. Professor George spoke about this today, that we've largely separated the idea of rights and duties, but more and more I think those duties are going to fall upon peoples and institutions that have a countervailing view of our dominant understanding of rights talk.
I mean, just on this point, I think this is a position that's often floated as a kind of, well, we need to think about community and we need to think about whose rights are being burdened, but I actually don't see the analysis making a lot of sense. Like, there's no claim, we all have rights. We all disagree about the exact contours and details of them and how they should be balanced against each other when they come into conflict. That's what makes constitutional law really hard. You can't write the simple test that would sort it all out perfectly. I really like the initial framing of there's the clear cases on one side and the clear cases on the other, and then the messy stuff in the middle. And I think that's where all the arguments happen. And then there's a question of, are we doing the best we can to accommodate everybody's rights? And so I actually am curious on the least restrictive means analysis. So there's the suggestion that this could have been done some other way, that this wasn't the way that it had to happen, that there would be some other means of doing it. And so I was thinking, well, I could imagine some other kinds of things. So the federal government could open clinics that were paid for by federal tax money, right? That's at least a theoretically possible way, but that's not a politically possible way, right? So one question is, what's the modal status of that claim that it could have been done some other way? Does it actually have to be politically viable that it could be done some other way? Or is it just there's a theoretical possibility? Because if we actually have rights interests on the other side, and we think there's a genuine interest here in the equality of women and the access to health care by women, if that's a genuine rights interest, I'm happy to also acknowledge there's genuine beliefs and values on the other side that conflict with one way of accommodating that interest. But I'd want to hear a more constructive proposal about what is an alternative that other people would find acceptable. And so, I mean, there are exemptions carved out already, but that's a large concession. You might think, well, if we also give all for-profit corporations the ability to carve out, we start to lose the pool from which we can actually fund and meet this other rights claim. So it sounds a little bit like empty rhetoric rather than sort of meaningful commitment to trying to find some way of accommodating these interests.
And just on just one thing on the least restrictive means part of it, because it's come up a lot, and I would say that it's not just about covering the cost of contraception, whether the government can provide contraception or give a tax break to women instead, but what we're talking about is the dignitary harm of being discriminated against by your employer. And so one of the cases we talk about in our brief is a case from the 1960s about a barbecue in the South that refused to serve blacks. And the barbecue was sued by a customer and under the federal public accommodations law. And the owner said, my religious beliefs, I object to integration. And the least restrictive means there wouldn't be, well, the government can pay for those customers' barbecue, or they can go next door. Part of what we're talking about is the dignitary harm and being discriminated against by your employer and eliminating that discrimination, just like Title VII guarantees and other anti-discrimination laws do as well.
Also, it's not ancient history, this history about discrimination. So the remarks were made that, well, yeah, so it could be used against African Americans, or it was used, these kind of religious-based arguments. These are the same exact arguments being made now against same-sex marriage, against all kinds of discrimination against gays and lesbians. And so people might think, look, that's different because discrimination against gays and lesbians isn't just like bigotry and prejudice. But if it is just bigotry and prejudice, it doesn't matter that it has a religious foundation. Because for a long time, discrimination against blacks had a religious foundation. Read the 19th century papers on slavery and the justification.
Wilberforce, for example, he would be one that we would put in that category. Okay, what if somebody said, the reason I object to the HHS mandate is because I'm an environmentalist and I feel the increase of birth control hormones in the water create intersex fish. Now, I don't think you can easily say, well, you know, that's really just a shell for discrimination against women, you know, something like that. What if the administrative agency said, you know what, we're going to add a requirement to the employer mandate. We've seen these studies in Africa that male circumcision really cuts down on AIDS. It's an AIDS preventative. So we're going to force all employers to pay for male circumcision. Now, see, you begin to start thinking that what I'm trying to do is kind of reverse the polarity of some of these things to show that all of this isn't like, well, if you say a religious claim, that's just like all these bigots in the past. You know, like Wilberforce and Martin Luther King Jr. and all these others that oppressed people by invoking the Bible as a basis for public policy. I also think there's a big difference between Ollie's Barbecue saying, I'm a bigot, I don't serve your kind here, and the government coming when it had all sorts of different ways that it could pay for abortions, like through existing programs, for example, that it already has to provide, and say, we're going to, and I like the way you put it, we're going to pick a fight with these religious owners and kind of stick it in their face and make them pay for it. I think there was a way like, you know, Justice Kennedy asked, so General Verrilli, that means that the government could force employers to pay for abortions. Even though there's no congressional mandate for it, the administrative agency could do that and say, and your position would be corporations can't challenge the mandate. And I just think that there's kind of a sense of unreality and making it sound like religion always, because some idiots in the past have invoked it to justify mistreatment of women and blacks, that therefore every religious-based claim is always evil. I mean, if they're really thinking that they're killing people by... Is
anyone saying that?
Well, I think that's what you said.
I think that's what you were saying. There's a lot of middle cases that are hard. So I think Hobby Lobby is a hard case in a certain way, right? So I think the discrimination, so like the Elaine photography case, I don't think that's a hard case. I don't think that private companies should be able to discriminate on the basis of sexual orientation. Because for this exact same reason that I don't think we should be able to allow
So like a website designer could be forced to set up a website for Westboro Baptist, and that would be religious discrimination, and there would be no compelled speech claim under your thinking of this. Because if you're out in the private marketplace, you surrender your First Amendment rights, and you can be compelled by the government to present other people's messages, even if they're deeply offensive.
I think it gets complicated. There might be complicated
Yeah, it's not a
cases.
simple case, right?
What I'm saying is I think there's a range of cases that we probably agree about in terms of being hard cases or cases in the middle, and then I think there's cases on the extremes that are pretty easy, that we'd all acknowledge would be easy. So, and it's certainly not my position, and I hope that was clear from my talk. I mean, I think people who are religious, including many people that I know very well, including my family, have deep moral commitments. Those moral commitments rule out or preclude certain kinds of things. They don't want to be involved in them.
Well, see, this
The
is
question
what
is how that interacts with everybody else.
I don't want to play moderator, but I would love to hear from a student because I think we could talk forever.
Can I just make a factual
If there's a student
point?
who wants to ask a question.
There weren't any hands earlier, so I
There we
wasn't
go.
I think I saw a student somewhere. Yeah.
Thank you. As entertaining and thought-provoking as that tit for tat was, I was wondering whether there's sort of another question underlying all these discussions. And like Mr. Lawrence, I do not come from a philosophical background, so hopefully some of the panelists can enlighten me on this. But isn't one of the questions really what kinds of corporations do we as a community believe are appropriate fora for advocating religious beliefs or conscience? So religious institutions clearly seem like the appropriate place to be advocating religious views. Nonprofit organizations that are not profit motivated, that want to take on a religious vantage point, seem like an appropriate vehicle for doing so. So isn't the question really how profit plays into it, what we as a society believe as to what really should be, whether profit-motivated corporations are the appropriate fora for religious views or advancing religious views?
I just say quickly that I actually think the analysis too has to include not just the profit enterprise, but the background sort of market-structured world we live in, so that if you foreclose employment opportunities to people on various grounds or make it more difficult or more expensive or a less good job, that alters their life opportunities. So it's not just the sort of profit motive. So I think of the Penn Health System just recently imposed a rule that they will not hire smokers. And many people saw this as unjustifiable given the background structure of employment and the need to have a job and that kind of thing. So that even if that was kind of the view of the people who run the Penn Health System, that smoking's bad, nobody should do it, it was somehow putting the cost on the wrong people to express that message that way. And I find this case to be similar in that way, but I would say the profit motive element is less important.
I think for me what's important, and I'll say that the ACLU actually doesn't take a position on whether companies can exercise religious liberty rights, but how it does play into the question for us is when you enter the public sphere, you play by public rules. And so if you choose to open a company and nobody tells you have to, you then have to comply with all of the federal rules and state rules and local rules, including anti-discrimination principles and including the contraception rule. And Justice Kagan, I believe, had focused on this in her line of questioning too, about when you open a business, then you are agreeing to abide by these number of rules. So I think it's part of entering the public sphere for that analysis.
I would just add that I think that the religious liberty issue is a bit stickier, but I think with freedom of speech, I have trouble, I caution people to say, hey, look, if you're a for-profit corporation and you enter the marketplace, you got to play by all the rules and you surrender your ability to challenge any of them. So if there's a corporation, if there's rules that you have to promise to vote for the governor or the mayor You have to make a political contribution to him in order to get a business license. You have to swear your allegiance to the Constitution or that communism is bad. You know, those are the rules. Well, then I think we intuitively say, well, wait. Those wouldn't be legitimate. But the thing is, then you have to say the Constitution puts parameters on what kind of rules and restrictions that the government can impose on the marketplace. And it's not like the marketplace is this First Amendment free zone. You have to agree to warrantless searches. You surrender your privilege against self-incrimination if you enter the marketplace. I don't think people would accept that, and so I think it depends on what the rules are. And just because you're for-profit and in the marketplace, I don't think there's anything magical like, oh, you don't have any constitutional protection, or they're somehow lessened, and you're being a prima donna, not playing by the rules. I don't think that that's a right way to look at it.
Yes, it's striking to me we're certainly entering a period in which a lot more talk about the relationship of morality and markets, and it seems to me that at a more profound level, philosophical level, and here I'll agree with my colleague on the end, that it seems to me businesses, corporations that do want to talk and do want to introduce the language of morality into the marketplace, we should give them, may ultimately be decided that that particular vantage is not in line with what are deemed to be government interests, but to suggest that in some way one checks one's conscience in this case at the door, one's effort to participate in the marketplace in a way in which morality is a part of that seems to me to be exactly the opposite of what we would want today. Just one other thing that I just want to put on the record, this discussion has, in part it seems to me it's based on certain false premise, which is it's been in some way set up as a debate between whether or not this company or these companies should be providing contraception. And I think it's important to put on the table, these companies are not actually challenging the view that they should be providing contraception. It's not like my institution, the University of Notre Dame, which is suing the government to avoid this mandate. They're actually arguing against the provision of 4 drugs that are proven abortifacients. This is not an easy case, and anyone who wants to suggest that it is entirely mistaken.
I just have to clarify that we're not talking about abortion here. As a scientific matter, as a religious matter, you can have whatever religious beliefs that you want in terms of what's contrary to science, but in terms of what disrupts an established pregnancy, contraception, birth control by definition doesn't do that.
But what's your answer to Justice Kennedy's question, that if it was surgical abortion, nobody disagreed, these are abortions, would you say that the government could force that on for-profit corporations and they would have no religious objection to it because the right of access to abortions is really significant for women?
Well, I think it depends on what's the compelling government interest, and particularly with respect to contraception, there's a direct connection between women's meaningful access to contraception and equal participation in society and the disparate healthcare costs that women have to face. So I think it depends, but there was a case out in the Ninth Circuit about students at a university who objected to paying into the healthcare system because of the coverage of abortion, and it was under RFRA before Bernie versus Flores, and the Ninth Circuit said it's too attenuated. You don't get to object to paying into a system that could fund another person's abortion. So I think that's instructive.
Just real quickly. This all may become moot, too. My colleague Zeke Emanuel, one of the architects of the Affordable Care Act, has the view that in 15 or 20 years, employment and health care will become largely decoupled, so that a lot of this getting into your private affairs and having to pay for things you don't want to as an employer will become distinct. And there's many reasons to think that could be a really good thing. It kind of keeps us out of each other's business in a way that might make a lot of these things easier.
All right, well, let's take our panel.